I get out and close the door, I look to my left and there were multiple police cars coming.
But then I looked up the street and they was coming from up the street too, so.
You know, we both like, we're not wanted, we don't have any drugs, we don't have any weapons.
I was confused of why that many cars was coming.
They swarm on us, separate us, cuff us up, and they don't even tell us what they arrest us for.
They handcuffed me and Derrick, put us in separate cars.
And I looked up in the window and I seen my mother looking out the window. And that was like one of the last images that I had heard that night when I was, before I went to jail.
I had got a phone call from Derrick's father saying that they was arrested. He was telling me to come up there and talk to him. So I didn't know at the time what was really going on. So when I went up there to go speak with him, he was saying something about some shooting happened around the corner. I'm like, oh yeah, I was in the truck with them, and we saw the shooting.
And first he was saying that, well, we talked to your friend Derrick, and that's not what he said.
You know, they was telling me that they had 30 witnesses.
He had 15 eyewitnesses that was putting us at the scene and said that we had killed the guy.
And that's when they try to make it seem like they had witnesses against me, saying I shot somebody.
They were saying LAURESE and EUGENE were saying totally different things, saying that it was me and everything like that. And I just kept telling them what I knew. First thing that morning, they drove us and shipped us down to the juvenile detention center. Me and EUGENE was 17, and LAURESE was 16.
The state's case at trial was two things. There's the testimony of Tamika Harris, who was the 14-year-old girl who said that she'd seen the shooter coming from behind LAURESE's truck, and that it was also gunshot residue that they had supposedly pulled from both the outside of the truck and from Derrick's sleeve and one of EUGENE's gloves. Whenever you fire a gun, there is what's called primer that ignites the gunpowder. That primer is made up of elements that you don't see very often in nature: antimony, barium, and lead, and they're fused together as part of the process of firing a round. Guns are not airtight, and so when you shoot a weapon, the primer from that gunshot residue will come out through various places in the gun and will oftentimes end up on the person's hands, where it can then be recovered and confirmed as being gunshot residue. So on the day of the shooting, Tamika says that she identifies EUGENE as being, of the 3 people in the car, only the person whose clothes were the closest to the person that she saw that day. Initially, that was all she said, and in fact, when she was asked at first whether she could identify the shooter, she noted that she wasn't wearing her glasses. She couldn't really see the person's face, but she sort of generally described the clothing the person was wearing as a dark blue jacket. So at trial, there are really 2 pieces of evidence against the 3 defendants. Tamika Harris, her identification of Eugene Johnson, and this gunshot residue, or what they said was gunshot residue that they supposedly found on the car and on Derrick Wheatt and on one of Eugene Johnson's gloves. When the state rested, they actually made a plea offer to Derrick and LAURESE.
They came to me, they said, if you testify and say that EUGENE did it, you will serve 6 months and get probation. And they told LAURESE if he testified against EUGENE that he would just walk because he had no record.
Telling me if you testify on EUGENE, they said they would let you go home today. So I'm like, no, I can't do that because, we innocent. Nah.
The plea offer signifies that the state knew that the case was weak. They knew that they didn't have much of a case, and they knew that they needed more in order to get a conviction.
Like, why would I do that? Tell you something, testify against somebody that's not the truth. So we never did. We never took that deal.
Both of them insisted they were innocent. They both refused to take the plea deal, and it went on to the jury.
I always thought that all of this would get corrected on appeal, and once the appeal went through, we'd get out, and that never happened. We went through appeal after appeal, then 1 and 2 years turned into 5 years, 5 years turned into 10 years, and I don't know, it just started looking bad.
They had us going to solitary confinement every year when a crime, allegedly happened. We supposed to think about what we supposedly done. To be locked up for something you didn't do, then every year gotta go to solitary confinement. I think that was kind of like my darkest moment. In 2004, I think that was kind of first kind of door opener when the state witness recanted.
She started thinking about the evolution of her testimony. She started thinking about what she actually saw that day. And she felt, I think, guilty about having exaggerated her testimony at the time of trial. She said that she felt pressured by police. I mean, it's understandable. She was 14 years old. She's trying to do the right thing. She has police and prosecutors telling her this is the right thing to do. She has police and prosecutors saying, we found the car that the shooters came from. We found the 3 guys. Which of these 3 is it? They were never asking her questions about whether she was sure that this was the shooter. It was building up her testimony as much as possible, and she responded to that pressure.
And so the Judge Russo, I granted me a new trial, but so the prosecutor appealed to the appellate courts and they overturned it. They were basically saying that the state could have still got a conviction based on the gunshot residue.
There was a study done in California where when you take random people from the street, swab their hands, confirm that there's no gunshot residue on them, and then you put them in the back of a squad car and drive them around for half an hour, let them out, and then swab them again, you had up to 1 out of 3 of those people end up testing positive for gunshot residue, and the reason being, of course, because the back of police cars are lousy with it, right? And gunshot residue is not something that is like glue, it's a light powder. It's going to, if it's on you, it's going to maybe transfer and get on other surfaces that you're interacting with. So when we started looking into the gunshot residue evidence and find all of these problems, the hope is that that's going to be enough to show that the conviction really, there's not any more support for it. Tamika Harris is recanted. The gunshot residue evidence has serious, serious flaws. These men should not be in prison for this. Ultimately, the appeals based on the gunshot residue evidence problems were unsuccessful.
That was another tough situation, but you just have to believe in God and just, when the going gets tough, the tough get going. You just gotta keep going, and that's what I did.
Yeah, that was like real difficult, and I don't know, you just have to have faith.
In 2013, an attorney with OIP, Kerry Wood, filed a public records request and specifically requested the police file from East Cleveland Police Department, where the detectives kept notes of all their interviews and everything they had done with the initial investigation. When we got back the public records request, on the very first page was a letter from the Cuyahoga County Prosecutor's Office.
Dated from 1998. And it basically said, like, if you guys release this, you're gonna be prosecutor, you ordered to send everything you got pertaining to this case to our office.
Apparently, One of the defendant's original attorneys had also requested public records back in the late 90s. And in response to that, the East Cleveland Police Department was ready to turn over those records.
It is public records. Anybody can go view anything about anybody's case once the case is over. It's public records. Anybody can see it.
There were multiple things that the police had known in 1995 and 1996 that had never been turned over to the defense. Maybe the most important thing that the police knew back then and never disclosed was there were 2 additional witnesses who were on the scene when the shooting occurred. Not only did these 2 new witnesses see that the shooter didn't come from the truck, but they actually claimed that they recognized the shooter as the older brother of one of their classmates.
He had seen what happened, and he think the shooter is a girl in his class brother. He seen them before.
There's no question that the information in the police records would have severely damaged the state's case. The state's case was so weak that they're offering 2 out of 3 defendants a complete walk if they'll testify against the shooter. And here in their file is evidence that basically it completely exonerates all 3 men. And they hid it, and that's unconstitutional. There's a case called Brady that requires the state to turn over evidence that is exculpatory and could be material to the defense. In January 2019, a trial court declared that they were actually innocent, and at that point, the case was over.
They always fought for us, and so, it's like a debt of gratitude to the Ohio Innocence Project that is so humongous, I don't even have words to explain it.